Hello everyone, welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have Mr. Justice Tan with us. He is a construction lawyer at WongPartnership LLP, Singapore headquartered and an award-winning law firm. Exactly a year back, in January 2021, he was selected as an accredited specialist in building and construction law by the Singapore Academy of Law, if I'm not wrong. And Justin was also ranked first in the exams. He has appeared in all levels of Singapore courts for construction disputes and successfully argued the landmark cases. We have an Audi case here. We'll be talking about that. We'll be talking about that in the further discussion. But before that, let me introduce you to the man himself. Hello, Justin. Thank you for joining us. And how are you doing?
I'm good. Thank you. Thank you for inviting me.
Oh, pleasure's all. As I said, thank you for joining us for the session. Justin, I had a lot of things to discuss here, but as I said, I left my remarks right before I was about to discuss a case that you were part of, and I would love to understand about that. But before that, if you can tell our viewers about a complex legal issue you worked upon, and describe the complexity that was there, and tell us how you really approached it.
Okay, so basically one of the biggest issue that I had to deal with was regarding construction adjudication. So construction adjudication is a statutory creation, which is to streamline the dispute process between construction parties. Because if you, just to give you some background, normally in construction, when there's a dispute over payment, the normal route to deal with it would be through litigation or going for arbitration, and both of which are very expensive and very lengthy. So adjudication was created as a new thing to sort of shortcut the process and make it a pay now, argue later process to deal with cash flow issues. However, even though this mechanism is supposed to be very fast and simple, over the years, there were a lot of case law that were created, which created several issues, and this resulted in the adjudication not being very fast or very simple. So I was involved in this case called Audi Construction and Kian Hiap. This case had a very wide impact on the construction industry, and the case law has since been codified into the statutory amendments to the relevant adjudication law in Singapore. I also did some research, and I was quite surprised to find out that the case has been cited more than 40 times over the last 3 years. So yeah, you can tell to the impact, at least with Singapore. So basically, for construction adjudication, there are only 3 steps to getting the dispute resolved in adjudication. The first step is to submit a valid claim under the project. Secondly, you have to submit a valid response you have to respond to the claim. And then after that is the adjudication process really. So it's supposed to be very fast and very quick. But many times what happens is that the respondents, they don't provide a response to the claim. So under adjudication, if you don't provide a response to the claim, what happens is that you're almost like there's an open goal if you go for like football, because you can't present any defense. Whether or not the claimant can still score the goal is up to them, but it just makes it very unlikely for them to lose and very likely for you to lose. Yeah, so when this situation happened, in this case, what happened is that the respondent did not provide a response. So what they tried to do is to try and knock out the claim on very technical jurisdictional grounds. And they try to find, and this is very common, at least prior to the case that I did. So they'll try and find all sorts of ways to say that the claim is an invalid claim. So in my case, so in my case, to serve the contract, you're supposed to do it on the 20th of each month. So in November 20th of that year, where the case was of that particular case, 20th of November happened to be a Sunday. And the office, the main contractor's office was closed on that day. So what my client did was to serve the claim on a Friday, the 18th of November, but they post-dated the claim to a Sunday. So the claim was dated 20th, although it was served on the 18th. just to make sure that the claim would comply with the contract. So when the claim was submitted for adjudication, there was no issues with it. The only issue that the respondent could find was that the claim was served on the 18th, and therefore they tried to run all sorts of arguments to say that the claim was invalid, even though they had no issues with the claim itself, except for the date. And so this was an example of a case which which the Court of Appeal had determined should not go on forever, because what happened in this case was that although there was an adjudication, this case went on later to the High Court, and then it was appealed again to the Court of Appeal. And the Court of Appeal said that this is a prime case where jurisdictional arguments like this should not be allowed. So what the Court of Appeal finally ruled was that they ruled on two things. Firstly, they found that the arguments saying that the claim was served too early was an invalid claim, so it was validly served. But the more important thing that I wanted to point out was that they said that if a respondent doesn't respond to a payment claim, especially about things like dates or something to do with the document itself, the claim document, you can't argue later on that the claim document is invalid. So the Court of Appeal's decision in this case was very important, because basically it makes both the owners on respondents to make sure that they object to everything that they need to in the response document, instead of only throwing it much later on at the adjudication or in the courts.
Well, I mean, that's right. I mean, it sounds like the process that was supposed to make the things easy made something very complex, and then when it has to go to again High Court and follow the same trails, and then cases like this should not be pooled in that category.
Yeah,
that's what happened there. All right. Okay. And this happened in which year, if you talk about this case?
This case was decided in 2017, but the decision came out in 2018, early 2018.
Early 2018. All right. Okay. Before pandemic, of course. Because what I thought that if this was happening in between the pandemic, there must have been more complexity that you must have faced. Anyways, in between, because now we are seeing that there's a third wave, or I should say the third version of COVID. The strain Omicron is coming along. We are again shutting down. I believe it goes same for every other geographies that people are watching us from. The pandemic saw some courts begin moving towards more remote proceedings across the globe in terms of the availability as well. Is this sustainable and a possible way to increase access to justice? What do you say?
Well, remote hearings are definitely more convenient for everybody. Especially if you are a foreign party and you can't travel into the country. But having said that, it might not necessarily be the very increased accessibility, because there sometimes, okay, let me preface this first. In most cases, yes, it is much more accessible and much more convenient for everybody involved. But there are some cases where this might not be so accessible, especially if you need the party to actually turn up in court in person to test the veracity of the person's evidence. Secondly, where there's very, very little trust between the parties, assuming like this witness is someone that you think is very important, but you are unable to bring that witness into Singapore. What happens is that even though the hearing is done remotely, most of the times people will want a lot of security to ensure that the person is not being coached behind the scenes or behind the camera. So what happens is that parties will want the witness to have cameras in many directions, in front of the person, behind the person, sometimes a omnidirectional camera in the whole room, just to ensure that the person is not being coached. So this actually increases costs because you need quite a few devices, and it might not be so accessible. But definitely for the vast majority of cases, and most of the time for the lawyers and the judges, it is very, very convenient.
Do you think it's about creating a whole system out of it? Because I mean, when we talk about a remote place, then that becomes a difficult task for them. I mean, in terms of the infrastructure, it's
Yes.
also necessary that one has to, a country should have an infrastructure to proceed further with the remote proceedings and remote availability of the cases.
Yes, I agree with you. Actually, I mean, to be frank, the infrastructure is mostly here already because like almost everyone has access to a smartphone, and which will be able to access Zoom or a similar device.
Mhm,
And I don't. It is possible for people to get multiple devices to make sure that they are seen everywhere.
mhm, mhm.
So it is definitely a step in the right direction, and I yes, I would agree with you that if the judiciary could come up with a more uh, systemized method to carry on with this remote hearing, it is definitely a good thing.
Mhm. Oh, fair enough. Fair enough. Okay. Now, if we talk about in a generic sense about the legal system, I mean, whether it be in the pandemic time or pre-pandemic or post-pandemic, how would you rate the current legal system's drive towards encouraging access to justice? And is there a tangible movement in closing the justice gap?
Yes, I would say that there is. I mean, I can speak specifically for the construction industry, and like especially with adjudication.
Mhm,
This adjudication process has been very helpful in increasing access to justice, particularly for the small and medium enterprises. Not so much for the main contractors or the developers, but for small and medium construction companies. This has significantly reduced the costs as well as the time required to litigate disputes between the parties, especially when it comes to cash flow.
mhm, mhm,
And most of the times, while there is a right to a final, a full hearing, I realized that in many of the cases, the construction parties, they just want to be heard in some way or another. A rough form of justice is really more than sufficient for most of them. And this adjudication process has been very useful for increasing this access.
mhm,
And if they were to be, if people consider putting the adjudication process to um, broader areas of the law and not just construction, I have a feeling that many people will be interested in this like rough form of justice
mhm.
and reserve the right to have a full hearing with the rules of evidence and all that. Yeah, I think this would be something that everybody, I mean the courts, the judiciary could consider.
Fair enough. Fair enough. Fair enough. Moving further, if we involve technology now into the legal era, I mean, in the era of legal technology, what are the most commonly used tools? Let's say for you, what are the tools that you use?
Well, we have an online research platform, so that is the most common thing we probably use. Um, Access to precedents will be also very useful because like now is precedents are not very easy to access.
Mhm,
The and I think the third one that we would use most often would be the file management system. However, I have seen the file management systems and they are not too much more advanced than what is available without those systems. Let's say, for example, Google Drive or Dropbox. I
mhm,
think those are already very good, subject to, of course, security concerns.
mhm, mhm. Okay, all right. Also talking about Justin, you have been involved with so many cases, and when we talk about cases, it's not a single thing that's going on in a lawyer's life. There are so many things going on for our viewers to understand. I mean, if they're litigating a single case, they're also drafting another one at the same time, or at least their team is working on that. So I always tend to ask, the time management formula. So as we say that time is money in any profession, and in legal it's most of all. How do
Yeah.
you ensure to make the best of your time as a lawyer?
Uh, well, you always have to get the basics right first. So you have to make sure you're updated on the law, and then after that, when you make your submissions, you have to make sure that they are accurate and concise. What I try to do is I try to read like textbooks, not just on legal text, but like by senior judges. So I read a book by Justice and Scalia from the U.S. Supreme Court. and he was teaching about how to write submissions and make oral arguments. So I read those things. So I there is an investment in terms of time. You have to put in the time to read the textbook. But I feel that once you've read it, everything you do from then on will be much better, because like you can apply whatever you've learned in the to all your writings later on. So yeah, I would say that would be the most that's the best way to make use of your time.
Okay, so you read a lot.
Yeah, I try to read.
Okay.
Yeah,
And you do you read the paper? I mean, the paperback or the Kindle version?
I read the Kindle version. I try not to buy the books. I also read books on like cross-examination. So you try to find those who are like very good at it, and then you try to distill the principles. So yeah, those are things that you try to learn.
Okay. Okay. Thank you very much, Justin, for sharing, such great insights with us for the day. I mean, we understand you are really busy and you got like 20-25 minutes for us for the session, and we really appreciate it. Before we leave you, before we, we allow you to leave the session, last question would be, where can our viewers really find you? Where can they learn more about you?
Oh, I have a profile on LinkedIn, so I update my LinkedIn quite regularly, and I also post my articles there. So yeah, if people want to find me, they can find me on LinkedIn. I think and my contact number is also there as well.
All right, cool. So we'll mention we'll mention Justin's LinkedIn ID in the description, so people if want to join him as a professional in his professional network can join him and can bombard him with his questions. He has a helping hand. All right, so thank you very much, Justin, for sharing such great insights with us. Meanwhile, and we look forward to having a chat with you again in the future on some other trending topics in the international legal industry.
Thank you.
And finally, for our viewers, if you like this chat with Justin, I want you to like this video, share this video, and click on that red button to subscribe to Click Away Creators YouTube channel to appreciate what we do. And you have more coming in from legal industry leaders like Justin Pan. This was Sagar for LexTalk World signing off. Thank you very much. Thank you, Justin.